All right, and welcome. Hello there. John Scholes, your host, as always, Disability Law Show. Good to have you back with us alongside Sivan, Tumarkin, co-founding partner Samfiru, Tumarkin LLP, the most positively reviewed law firm in the country, and besides Sivan, partner James Fireman. Guys, good to have you back. Good to see both of you. Lots of stuff to get through in the show today. 3 ways to make your LTD claim stronger. That is coming up in just a bit, so we got a full hour. It's going to be packed full of information, so feel free to stick around for the entire thing. If you want to reach out after this show, simple, 1-855-821-5900. The number. Email is help@disabilityrights.ca. And there's a website built just for you to ask questions anytime. It's free, it's anonymous, called mydisabilityquestions.com. Guys, let's get into it. Sivan, we always start off with a week that was a case of the day. What do you got going, pal?
John, great to be with you here and with James and our viewers. I want to tell you about an interesting situation I had earlier this week, and I have to be careful because it was a confidential process, but I will not mention any names. It was a mediation, which is a process where we resolve claims, long-term disability claims and other types of claims. And in this particular instance, we resolved that claim that day at the mediation, but the adjuster for the insurance company had made an interesting comment to me. And it was like an off-the-record, off-the-cuff type comment that he had made. Our client suffered from a brain injury, a mild brain injury. Which, oftentimes when people get diagnosed with these kinds of injuries, they're diagnosed with concussion. And a concussion is a brain injury. You can Google that, okay? That's just a fact. And this adjuster had made the comment that nowadays he sees a lot of these concussions, these mild brain injuries, mild traumatic brain injuries. And then he said, it used to be like fibromyalgia back in the day, chronic pain back in the day. As though he's diminishing what that means for individuals who are in fact suffering from fibromyalgia, from chronic pain, from these kinds of illnesses that affect them and oftentimes are debilitating to individuals. Now, don't get me wrong. This person, I don't think that he tried to, say this in a negative way towards the individual that I was representing at the mediation. I think he was just saying it as a general outlook that insurance companies and adjusters in general look at, right? I mean, they're not seeing a broken bone. They are seeing something that oftentimes doesn't have objective, quote-unquote, evidence. They can't see it on an X-ray. Just like you can't see, oftentimes, a back injury on an X-ray, right? You have a strained back, you're not going to see it on imaging. Mm-hmm. In any event, we resolved that claim, but what I think it highlighted is that insurance companies oftentimes downplay these kinds of conditions. People suffer every day from conditions like a chronic pain condition, fibromyalgia, traumatic brain injuries, psychological types of injuries, which of course you're not going to see on an X-ray or an MRI. And yet these kinds of conditions are completely debilitating. Individuals cannot go to work. They cannot maintain their jobs. And insurance companies, unfortunately, use that to their advantage. And individuals don't get paid. They get cut off disability. They get denied long-term disability. And so we have a lot of experience in that. And, again, this is an example of a case that we had settled successfully. The client was very happy. But I bet you there are many people out there who are dealing with insurance companies who are very skeptical of those kinds of conditions and at the end of the day don't pay anything. And these individuals think that they're not entitled to this money, and they are.
I think it's really great that you're bringing it up, especially with mild traumatic brain injuries or concussions. It's something I see all the time where we have insurance adjusters, and even when you get to litigation, you have the litigation adjusters will minimize it as you're discussing. And part of the reason for that, we often see insurance companies are going to rely on these medical guidelines as opposed to actually speaking with the doctor. And the medical guidelines will often talk about the typical recovery period for any particular kind of diagnosis. So they might say for a mild traumatic brain injury, the typical recovery time is 6 weeks or 10 weeks or whatever it says. But that is an uncomplicated situation that is in a vacuum. That's not talking about this particular individual. It's not coming from a doctor looking at the medical chart for an individual. And what we know about traumatic brain injuries, anybody who's dealt in this area before understands that there are all sorts of things that are going to affect the recovery period. If you suffer from depression or anxiety, that's going to affect it. If you have had multiple traumatic brain injuries in the past, or even just one in the past, that can affect it as well. And even if you have none of those factors, we also know that it's only what is typical, but that doesn't mean that's what's going to happen for any particular individual. And because of that, to suggest that, oh, well, you're past the expected time frame for recovery and therefore we're not going to support your claim for benefits is ridiculous. You know, our late friend Terry Corcoran, great friend of the show, he would rail about insurers talking about these medical, or using the medical guidelines as a basis for denying a claim, and it is ridiculous. And when we get to the litigation stage and we're able to highlight that it's completely inappropriate to rely on the expected recovery time for a particular condition as opposed to what this person is actually suffering with, that's something that the insurers are always going to have to recognize, because they know if they are not reasonable, at the end of the day, they're going to be in front of a judge, and a judge won't accept that. They're not going to accept that some book says that this is the expected timeline, even though that's obviously not what's happening with the individual.
Would you guys say that if you rewound the clock 10 years ago compared to today, insurance companies have their eyes open a little more to brain injuries than they would before? Are they getting better with this because of what you guys do?
I don't know. I would say that's true generally with mental health claims.
Right.
So with depression and anxiety, there has been a change in how I see insurance companies respond to that, even over the last 5 years. I don't know that I believe that to be true for brain injuries. I don't know if your experience is different.
Well, I mean, what I would say about that is that it's not that their eyes are more open, it's that courts and judges have recognized that these are legitimate conditions and insurance companies have no choice. Right? And this is why, again, when people are suffering from these conditions and they're dealing with an insurance company that seems unsympathetic, is not listening to you, the adjuster is simply ignoring what your doctors are saying, people think they have no alternatives, no choice, and that's just not the case. When James and I and members of our team are representing someone and we're dealing with the insurance company directly, and they know that we know, they don't pull any of that stuff. I mean, they try sometimes, but they understand that that's not going to matter. Because if that case ended up before a judge, and by the way, almost never do these cases ever go to court because insurance companies understand what's at stake for them and they're going to get hammered. But whenever we're dealing with these kinds of cases, insurance companies typically, I mean, generally speaking, come to the table and they pay. They understand that there's no way around it. So it's not a matter of whether their eyes are opened. It's that courts across the country have recognized that these are legitimate conditions.
Again, reaching out anytime, help@disabilityrights.ca. And if you've caught our other show, the Employment Law Show with Sivan's partner, Leora, we've often talked about something called pocketemploymentlawyer.ca. It's got the employment word in there, but there's also a section, Sivan, on disability law. Why is that?
Well, the reason for that is because, you know, our specialties for anybody that has dealt with our firm is employment law and long-term disability law. And oftentimes there's an interplay between them. People who have difficulties at work and issues at work often suffer from some kind of a disability. They claim long-term disability, they get denied long-term disability, and then you have all these issues, and we're going to come across some of these emails later in the show, where people are then getting pushed by their employers either to return to work or they fire them, and at the same time the insurance company cuts them off or denies their LTD benefits. And so the Pocket Employment Lawyer was designed not to just provide free, accessible answers for individuals who are having employment issues, but also on the long-term disability front. Look, if you only have an employment issue, go to that website and you will get the answers that you need for your employment case. But if you have a long-term disability issue, whether it's intertwined with an employment one or not, it doesn't matter. You can go to that website and, again, get answers. And, of course, if at that point you're getting those answers, you want to speak with us, it doesn't cost anything. Any of our lawyers will speak with you for free about your situation. We do this each and every day, people who have issues with their long-term disability insurance. So that's why we have that in that website, John, because people oftentimes experience issues not just on the employment side, but on the long-term disability side of things.
And as Sivan mentioned, there is contact there, pocketemploymentlawyer.ca at the top right if you want to reach out after you've done all the reading you need to do. You did mention email. I want to get into the first one of the show today, guys. Again, help@disabilityrights.ca. Vanessa says, guys, I was on long-term disability for over a year due to severe back pain. I resumed my position as a supervisor against my doctor's orders, and despite still being in pain, I only returned because both my employer and insurer were pressuring me to return to work. I'm pretty sure I need more time off to heal. What happens if my employer and insurance company push back? There you go.
Well, that's a really good question, Vanessa. And I should start by reminding our listeners, our viewers, I should say, that the decision whether or not to return to work is fundamentally a medical decision. It isn't an employment decision or a legal decision at its heart. And I say that because when you're deciding whether or not you should go back to work, the first person that you need to talk to is your doctor. You should not be returning to work unless your doctor has provided you medical clearance, or at the very least has set out the limitations and restrictions that are going to be necessary in order for you to be able to successfully try and do that. And I also tell my clients that I certainly encourage them to go back to work when they're ready, but if they don't feel at least reasonably optimistic that they're going to successfully be able to return to work, then it probably isn't the right time. You're never going to be 100% sure that it's the right time to go back. You're never going to get a message from God that says now is the time.
Right.
But you do need to, in addition to getting medical clearance, be at least reasonably optimistic. In this particular case, Vanessa has gone back despite the fact that her doctor was saying it's not the right time, because she felt pressure from the insurer and from the employer. And that's just a reality that some people are going to have. They're going to have pressure from the insurer and the employer, or they're just going to be facing a financial reality where they need to do it. If their insurer is going to cut them off, they need to have the funds right away. That's unfortunate, and I would always encourage people to not return until they're ready. And if their insurer cuts them off, then you bring a lawsuit, you bring a legal claim, and you get those benefits from your insurer. But if you're in a situation like Vanessa is right now, and you're trying to go back to work, and you're afraid that your employer and the insurer aren't going to abide by that, there is a provision in any standard disability policy. It's called a recurrence clause. And so what that means is if you try to return to work after you've been approved for benefits, and you try to return to work, and you have been there for usually 6 months or less, and you're not able to continue working because of the same disability that had been preventing you from working before you returned, then you're entitled to go back onto claim and continue getting your benefits, in theory. It's not always the case. You're supposed to be able to do it, but that requires the insurer to accept that you are again or still disabled based on the same disability that you had before. But that is what you would do. You would advise your insurer that you intend to go back onto claim because you continue to be disabled. You would want to provide them with medical support from your doctor showing that that continues to be true, and you would request that they continue paying your benefits from that point forward. If they did not agree to do that, then of course you would call us and we would start a legal claim.
What do you think, Sivan?
I think it was a perfect answer. What I want to focus on is not the legalities, which is what James covered perfectly. I want to focus on the last sentence, which is what happens if my employer and insurance company push back. And it's that feeling of getting pushed around. It's that feeling of being between a rock and a hard place with the insurance company, with the employer. And what I want to tell people is that that's why we are here. Not just to give you information, but if push comes to shove, we push back a lot harder than these employers and insurance companies ever do. That's how we get the money for our clients. Now, we don't tell people, we're not trigger happy. We're not saying retain us and let us do, what we need to do right now if the situation doesn't call for it. That's what we give advice. Here's what you can do. Jave gave Vanessa some advice about the recurrence clause and other types of things, and we can do that. We can give you the advice you need. But if at the end of the day you feel like you are being pushed out, the employer is not accommodating you or is not helping you do what you need to do to be able to go back to work or to take some time off, and the insurance company, washes their hands clean, it doesn't work like that. They're not above the law. I don't care how big the employer is. I don't care how many billions of dollars these insurance companies have. We push back harder. So when the insurance company at the end of the day writes a nice fat check to our clients, it's not because they're a charity. It's because they've been forced to do so. That's it. We know the game, we know their game, and we use that to our client's advantage.
Guys, short break. I want to get into this afterwards. 3 ways to make an LTD claim stronger. That is coming up, so stick around. In the meantime, 1-855-821-5900 to reach out to these gentlemen and their team, and help at disabilityrights.ca as well. Stick around. We're coming right back. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Disability Law Show. John Scholes here along Sivan, Tumarkin, James Fireman, always here to educate you over this hour. If you want to reach out during or after the show, it's really simple. 1-855-821-5900. The number, email help@disabilityrights.ca. And I'll mention another place where you can ask free questions anonymously. There's also a searchable database, so maybe a question you're thinking of has come up in the past. It'll save you a bit of time, right? mydisabilityquestions.com. Again, it's always free and anonymous. Guys, let's get into this. 3 ways to make an LTD claim stronger. I don't know who wants to take the first one, but I'm going to throw it out there. Number 1, obtain the support of a treating doctor and have detailed medical reports. Sounds obvious, but yeah.
It sounds obvious, but John, it doesn't always happen. And the problem is, you know, when people come to us and they're denied long-term disability, one of the first things we ask for, other than seeing the denial letter, is show us the medical documentation you've given the insurance company. And sometimes they tell us, well, I don't have, you know, a supporting doctor. And the problem is that you may be disabled. We may believe that you're disabled, but it's not about what we believe, it's about what we can prove. And it's absolutely critical that you have a doctor, someone who's treating you, who's able to provide coherent opinion in favor of you, of your application, meaning that you cannot work, and explaining why medically. Now, sometimes we have individuals contacting us saying, I've been denied my long-term disability, and I'll tell them, okay, show me the medical documentation you've given the insurance company, and they give me clinical notes and records, essentially handwritten records. And of course, John, you know, with many doctors, you can't read what they say. And even if you can, even if it's typed, it's medical jargon. It doesn't necessarily actually say that you are disabled, or here are the issues, here are the impairments, here's the condition, etc. And so you need to make sure that whatever you give the insurance company, first of all, you have someone supporting you being off work because of your disability. And number 2, that whatever you give the insurance company actually provides this substantive information to the insurer. If you're not giving the insurance company something to work with, I can tell you 9 out of 10 times, if not 10 out of 10 times, the insurance company will deny your claim. It's just the way it is. And so we come in oftentimes and we have to fix that situation. Sometimes we have to make sure we communicate with the doctors to understand a bit more about the condition. Now, John, one of the other websites that we often mention is LTDFAQ.ca. Long-term disability, frequently asked questions. We've created that website as a free website for the general public. It contains very quick and easy memorandums, no legalese in there, and one of the memos in there, I think it's 2 or 3 pages long, is about doctors' reports. And it's essentially just a Coles notes on what should be contained, generally speaking, in these medical reports. By the way, John, I've had doctors contact me saying that document was helpful, because doctors themselves don't know what to write. They have no idea what the insurance company wants or needs. And so again, just to recap, you need to make sure that you have someone that's treating you, preferably a medical doctor, supporting you being off work if you cannot work, explain why that condition impairs you from a functional standpoint, and you've got to give that to the insurance company as part of your application. And if you do that, there's a higher chance that your LTD claim will be approved. And frankly, if you are denied down the road or cut off, again, it gives us something to work with as well.
Yeah, it's really important to remember that doctors are there to treat you medically, but they're often not thinking about the impact that it's going to have on your employment. It's just not where their mind is trained to go to. And so it's important to bring your doctor's focus into that particular area. Talk to your doctor not just about your condition, but also about how it's impacting your ability to work, your ability to earn an income, what you're required to do, and how those functional limitations are going to prevent you from doing it.
We were talking about 3 ways to make your LTD claim stronger. Number 2, James, I'll throw this one at you first off. Comply with all necessary treatment recommendations. Sure.
So, yeah, I mean, this seems very obvious, and it is, both from a legal and medical standpoint. You have to follow the treatment recommendations that your doctor is giving you. But likewise, that doesn't mean that because your doctor is prescribing you a particular medication today, that you have to continue taking that medication forevermore. It has to work. If it's not working, both from a medical and legal perspective, you have to go back to your doctor and say, listen, this is what's happening. It's not addressing the issues that I needed to, or I'm having these side effects. And then your doctor is going to take a look at it and say, okay, well, you would expect that early on, stay with it for a little while. And so you do that. Or they'll say, okay, let's pull the brakes on that and let's try something new. Whatever your doctor is recommending is what you should do. But you have to make sure that you keep your doctor informed of what's happening, what your reaction is to that medication, and whether it's actually doing what it's intended. If it's not, then you change, and that's perfectly fine. You should be doing that, and that's going to help your claim because it's going to show the insurance company that you're not just complying with your medical treatment, but you're actively seeking out better treatment. And that is only going to support your claim. It's only going to help to show the insurance company that this is a legitimate disability.
Yeah, don't just stop, right, Sivan? Like just, oh, it's not working for me. I'm not going to tell my doctor I'm just going to stop taking this medication. Don't do that.
And that's the problem, John. First of all, we can do a whole show just about treatment recommendations. What do you do if the insurance doctor makes recommendations? Do you have to follow those if they're contrary to your own doctor's recommendations? And we'll get to all this in good time. But one of the things that we find sometimes that's a bit frustrating, and I understand why people are doing it, but it doesn't help their case, is when they've tried various treatments, let's say a psychological issue, a psychological claim, PTSD or anxiety, depression, etc., and the medications are not working, or the person has an issue with the medication that makes them worse for whatever reason. And they try one medication, they try another, different treatments, and at some point they give up and they tell us, nothing works. The problem with you saying nothing works and you're no longer going to try something else, and you're not communicating with your doctors, is you've just given the insurance company ammunition to cut off your benefits. Because there is a provision in the insurance contract that says you must undergo reasonable medical treatments or treatments, whatever the verbiage is. And they oftentimes, James and I see this a lot, where they cut people off because they're saying you are non-compliant. Now, if you have a communication with your doctor, psychiatrist, chronic pain specialist, whatever, if you're speaking with them and you're trying different things, even if it's the bare minimum, we have something to work with. The insurance company should not be cutting you off. But if you're doing nothing, if you've just given up, the insurance company may have a legitimate reason here, at law, to cut off your benefits. So you don't want to be in that position.
Let's get to one more of these guys before we break. We're talking about ways to make your LTD claims stronger, and that is get all communication with the insurance adjuster in writing, though, in writing.
Everything. I mean, James speaks to this all the time. We tell our clients this all the time. We say this on TV, on radio. Look, you are communicating with your adjuster at different times, by phone calls, emails, etc. You want to make sure that there is a record, preferably a contemporaneous record, of any communications you have had with the adjuster. Because you don't know what the adjuster is recording on the other side of the phone. You don't know if Bob is calling you, hey, John, how are you doing today? And you're saying, well, I'm doing fine today. And then you proceed to tell Bob all the information, everything that's bothering you and why you still can't get out of bed. Meanwhile, Bob put in his notes that John said that he's fine today. Right? So you want to make sure that after every phone call, if in fact you communicate by phone calls, that you confirm those communications in writing. And James likes to say, and I agree with him, don't use adjectives, just be very factual. Be very factual. And it doesn't matter if the adjuster responds back. The point is you've put it in writing. Do it by email. It's very easy, and that way you have this record. And John, I can tell you that we've had cases where these kinds of communications have, really were very powerful in the case. Especially, by the way, when we're dealing with a case where you have an aggressive adjuster or an adjuster that is, doesn't appear to be sympathetic, perhaps is pushing you to go back to work, and you're trying to explain why it is you're not ready. You want to make sure that any communications between you and that adjuster is recorded. I'm not saying record the person, with a tape. I'm saying confirm in writing what was said. Don't worry about whether they respond or not. You need to have that communication and then store it somewhere.
One more. Sorry, go ahead.
Actually, I do want to give an example of where that can be really, really useful with aggressive adjusters. A lot of times we hear from clients that adjusters are suggesting things to them about the policy that we know isn't the case. For example, when you come up at that 2-year mark after you start getting benefits, we call it the change of definition. And it becomes harder to continue to get benefits after that 2-year mark, but it doesn't mean the policy is over. But there are countless examples of clients that have called and said, oh yeah, my adjuster said, it's a 2-year mark and my policy only goes for 2 years, and so I'm getting cut off at that point. Is there anything I can do? And I say, unless you've got a very unusual policy, your policy isn't just for 2 years, it's probably to age 65, and while there is a change of definition, it doesn't mean the policy is over. Right. So what you need to do is write to your adjuster and say, I understand from our conversation that my policy is only for 2 years. Is that correct? And if you put that in writing, your adjuster is going to have this out there, and they're going to have to correct themselves. Right. They're going to have to say, oh, well, no, if you heard that, then you must have misunderstood. What I really meant was it's only a change of definition.
Gotcha. A little bit more to go, guys. We've got to take a short break, and we'll do so and come back with more right here on the Disability Law Show. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. Alrighty, welcome back. Disability Law Show. John Scholes here. James Fireman, Sivan, Tumarkin. There is another place for you to ask questions anytime, anonymously. mydisabilityquestions.com, so use that whenever you want. Paul from that particular website writes in, guys, says, I'm on LTD due to significant mental illness and undergoing treatment, including antidepressants, psychotherapy, and exercise. My insurer is suggesting a new treatment which carries the risk of long-term side effects. Can my benefits be cut off if I don't follow their recommendations?
The short answer is that, John, insurance companies cut people's benefits, long-term disability benefits, for any number of reasons. So the answer, the simple answer, the loaded simple answer is right. Yes, they can. They can also cut off your benefits if they don't like the color of your shirt. It doesn't mean that they're going to be able to, maintain that position once we go after them for those benefits. Look, your obligation, and James and I talk about this all the time, is to try and get better. And what we tell people, and I think it's the correct advice here, and doctors across the country will agree with us, I believe, is to follow your treating doctor's recommendations. And so if the insurance company is suggesting a treatment, maybe your doctor hasn't thought about it, perhaps. Okay, so run this by your doctor, provide the report or whatever information the insurance company is giving you to your doctor and see what they say. But if your doctor advises against it, I would go with what your doctor is saying. I would trust them, not whatever the insurance company is saying. And if the insurance company cuts you off for any reason, and if the insurance company tries to bully you and tell you that you have to follow whatever they're telling you, the answer is absolutely not. You need to do what's best for you medically. Let us deal with the legalities, and if there's a fallout, we will hit them back.
Remember that the insurance company has their own agenda.
Yep.
They want you off claim, they want you back at work.
Right.
So if they're recommending this, it might be a Band-Aid. It might actually be something that in the very short term will help you. But what about the long-term effects? Is this are they asking you to take a narcotic? Are they asking you to do something that is going to damage your liver or your organs? So you want to make sure that your doctor is aware of it and that your doctor either says yes or no, and listen to what your doctor has to say.
And that is all we have to say for today. Appreciate you sticking around. In the meantime, contact or reach out to Sivan or James or their team. No problem. 1-855-821-5900. The email address we always go to, help@disabilityrights. Sivan also mentioned LTDFAQ.ca. That's for short little memos on disability. Easy to read, right? And then finally, mydisabilityquestions.com. Anytime you want to use that, there's contact information. It's free and anonymous as well. Thank you for joining us, and we'll catch you next time on the Disability Law Show.